Hello and good morning, everyone. My name is Jillian Bender-Cormier. I'm brand manager with Bender Insurance Solutions. We want to welcome you to another educational Bender U webinar, Navigating PAGA, What Employers Need to Know. Some housekeeping notes. If you have any questions during the webinar, please feel free to type them into the chat box or in the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I'll be sharing other questions you might have with our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout today's session. This session is being recorded. At the conclusion of the webinar, the recording link, as well as a copy of the slide deck, will be forwarded to you. We have an incredible expert sharing with us this morning, but I'll let our own Vice President of Alternative Risk, Roland Gillen, have the honor of introducing him. Welcome, Roland.
Thank you, Jillian, and good morning, everyone. And thank you for joining us this morning for a very timely webinar. Our guest speaker is Derek Decker with Crow & Decker LLP here in Sacramento. Derek formed the law firm with his business partner, Sean Crow, so that they could build a business that would take care of their clients, provide top-notch legal service, and create an environment where their employees love coming to work. Derek practices civil litigation, handles transactional work, and provides day-to-day legal advice to all types of businesses. I know my customers have appreciated his service. And he has also represented parties ranging from sole proprietors to multinational corporations. Derek is a member of the Sacramento Bar Association, has acted as pro bono counsel for the Sacramento Midtown Business Association, and is a current member of the Sacramento Downtown Partnership. Welcome, Derek.
Thank you, Roland, and thank you, Jillian. Good morning, everybody. I can't see your faces on video. I'm sure you can see mine. I'm a little used to the boxes at the top. Our presentation today, as Jillian said, is on the Private Attorneys General Act, or PAGA, in California. We've got an hour to go through things, so I will be going through things fairly quickly. Going to keep things as simple as possible. Like Jillian said, if anybody has any questions while we're going along, feel free to ask them, because I know some of this stuff, the concepts behind it might be a little dense at sometimes. So happy to talk about any of these issues in more detail as we go through it. So today you're going to learn what a PAGA lawsuit is and how they work, why PAGA lawsuits are, I would say, uniquely threatening amongst most laws, and what causes a PAGA lawsuit to be filed, and how to avoid or defeat PAGA lawsuits. I will say the emphasis with that last one is on avoiding them, because if there's grounds for a PAGA, it's usually off to not a good start. So first, what are PAGA lawsuits? What are Private Attorneys General Act lawsuits, and how do they work? PAGA, the statutes that created PAGA are in the Labor Code. They were enacted in 2003. They were intended to improve statewide enforcement of Labor Code violations. One of the first California Supreme Court cases that addressed PAGA had this quote, which is, "It is in the public interest to allow aggrieved employees acting as private attorneys general to recover civil penalties for labor code violations, with the understanding that labor law enforcement agencies were to retain primacy over private enforcement." So relatively simple conceptually. It is a statutory mechanism. PAGA is a statutory mechanism by which labor code violations, and there's numerous requirements, numerous potential violations in the labor code. This all relates to wage and hour issues. It's a statutory mechanism by which these violations or alleged violations can be addressed on behalf of all employees of a company, or substantial majority of employees at a company. In one way, it's different than a class action lawsuit, but conceptually it can help if you've never gone through one or you've never dealt with one to think of it as a class action lawsuit. The PAGAs, you don't get the same type of defenses in a class action lawsuit. We'll get to that later. But the idea is the plaintiffs in a PAGA action are trying to accumulate what are small penalties generally in the labor code, base them on the number of employees, and they are seeking, in many cases, pretty significant damages. The primary authority to bring a PAGA action is Labor Code 2699. This is the language of 2699, and I'm not intending to bore anybody with nonstop statutory language, but at least conceptually, again, I think it helps to look at this and understand, how these things are brought and what they mean conceptually, because some of the difficulties with a PAGA is understanding it conceptually. It doesn't function exactly like what I would call a typical civil lawsuit. So Labor Code 2699 says that any provision of this code, so we're talking about the labor code, that provides for a civil penalty to be assessed and collected by the Labor and Workforce Development Agency, also known as the LWDA, or any of its departments, divisions, commissions, boards, agencies, or employees for a violation of this code, the labor code again, may as an alternative be recovered through a civil action brought by an aggrieved employee on behalf of himself or herself and other current or former employees pursuant to the procedures specified in 2699.3. So that's compared to some statutes, that's a relatively short citation. That is really the mechanism, that language is the mechanism through which these actions are brought. I will say that despite the fact that these statutes were enacted in 2003, courts are still grappling with and struggling and deciding certain things relating to PAGA actions. And some of it derives from the fact that, in some ways, this is kind of a vague, broad statement. The PAGA statutes do not have specific procedural mechanisms in them other than this for the most part. They have not been addressed by courts in the same sense that class action lawsuits have. And so you don't have some of the same procedures and standards and understanding. Those things are still developing in the court. But looking at this language, one of the important phrases or words in here is this action, this alternative action to go after these penalties can be brought by an aggrieved employee. So the courts have largely addressed what is an aggrieved employee. An aggrieved employee only means that the plaintiff in this action must have suffered at least one of the alleged labor code violations in the action. So there could be a PAGA action raising a host of different labor code violations, meal breaks, rest breaks, things like that. But you need a named plaintiff to bring the action. So that plaintiff has to be a current or a former employee who has suffered at least one of these labor code violations. It's a pretty low standard. It is a standard that is easier to meet than what class actions require to bring them. So in most cases, whether or not someone is a aggrieved employee is very important. If the plaintiff is bringing the action and they don't fit this definition, the action could potentially be dismissed. But again, it's a pretty easy standard to meet. There's an important concept with PAGAs, and this is the idea that the plaintiff, the employee who is the named plaintiff in the action, is stepping into the shoes of the Labor and Workforce Development Agency. These are really actions brought on behalf of the state through a named plaintiff. It's important conceptually because it does drive some of the decisions that the courts have made and how they look at them, including, we'll get to it a little bit, a very important California Supreme Court decision called Adolph that's coming out. There was a US Supreme Court called Viking, and those cases are really at the forefront of some of the PAGA issues right now, the PAGA defenses. But inherent in those cases is the idea that it's not like a class action in the sense that it's a collection of just group people. Legally, it's being brought on behalf of the state. If there is a recovery in a PAGA action, it is split. 25% go to the employees in the action. 25% goes to the LWDA Education Fund. 50% goes to the LWDA. So we have 75% of the recovery going to the state. There's a lot of PAGA actions. There's thousands of cases sometimes filed every year. The number is increasing. The estimate that I've seen is between 2017 to 2022, there was approximately $5 billion in settlements. A lot of this information is, well, all of it should be publicly available because courts have to approve the settlements. So the state has a website where you can actually go through and look and find what PAGA actions have been filed. But, you know, inherent with this is the state's getting a lot of money also from these actions. If a PAGA lawsuit is filed, it is similar in many ways to other civil actions. I know I said it's different. It is a different case, but you're still going to have a complaint. You're going to have a summons. It's going to be served on the employer, on the business. There's one issue in terms of the deadlines and the recovery period for these actions. They only go back 1 year. So whenever the complaint is filed or the lawsuit is filed, they go back 1 year to collect penalties, which is a shorter period of time than if you were dealing with just a straightforward wage and hour, you know, action or a labor commissioner action. Some people may have gone through those. Some of your businesses may have gone through those, or even a class action. Those will generally go back 3 years, 4 years, depending on what the violations are. PAGA is 1 year back. These lawsuits will be preceded, or they should be preceded. Everyone I've seen, they have been, by a letter, very likely from a law firm, addressed to the LWDA. The employer, the business, will be copied on it. And it will be a letter to the LWA setting forth the alleged violations of the labor code. Some of them will be longer than others. Some of them will have more detail than others. Some of them will look a little bit template. Some of the language in it may be things that the law firm doesn't know if they can prove yet. They don't necessarily have the information yet. And so some of the things in the letter will be things that if you receive it as a business, you'll look at it and you'll say that absolutely that is not something that happened. But the purpose of these letters is to provide to the government agency the facts and theories for the alleged labor code violations. The LWA, once they get these letters, must provide notice to the employee and the employer if the agency is not going to investigate. They're supposed to do that within 60 days. So they're supposed to issue something saying we're either going to investigate or, you know, we're not going to investigate. At which point, if the LWDA is not investigating, the plaintiff employee on behalf of the state agency can now bring that PAGA action. A little side point here. I personally, and I've heard that it has happened, but I haven't seen the LWDA investigate. Our office has actually asked the LWDA to investigate on several occasions. The reason being, and we'll get to some of this later, the reason being is these lawsuits are filed by a private law firm. They're often filed by a law firm that may do PAGA actions as their sole source of business. There are attorney's fees associated with that. There are attorney's fees that those law firms are trying to recover that become an issue in the case. And so personally, to me, I think it would actually be a better situation if the state agencies would investigate, because you don't have that monetary motive to the same degree. A PAGA lawsuit can be combined with class action allegations. Importantly, a PAGA seeks and can only recover penalties. They are civil penalties. Certain labor code sections will have their own penalties in the statute. There is a default penalty rate under PAGA if the labor code violation at issue does not have its own penalty already. So a PAGA action seeks only penalties. However, they can be combined with class actions. Class actions can seek damages as we talked about, they can go for a longer period of time back to look at those violations. And there's a very important defense to a class action, because class actions have been around for a while. They've been litigated heavily. They've been extensively decided. California cases have gone up to the US Supreme Court. And so there's a pretty good understanding and procedure and standards for how class actions will work. And there's ways to significantly protect your company against a class action. But if that is not something that's been implemented at a specific company, you may see a PAGA action combined with a class action. As we discussed, the basic civil procedure under the Code of Civil Procedure, applicable to all civil lawsuits, is going to apply to PAGA actions. There may be some exceptions in terms of how things are handled, or nuances due to the number, essentially, of claims at issue in a PAGA action. This is a sample of, I took this just from the internet. This is a front page of what appears to be and is, I assume, a class action lawsuit. It lists out 10 alleged violations in it. But if you look at number 10, it says penalties pursuant to the Labor Code, Private Attorney General Act, California Labor Code 2698, et cetera. What that means is this is a class action lawsuit. It's also a PAGA lawsuit. They're also seeking these civil penalties under PAGA. So if your business happens to encounter a PAGA lawsuit, you might see it stated as just purely a PAGA lawsuit. You might see it stated, however, as a class action lawsuit, and then the PAGA is kind of thrown in there. But by doing this, by citing the Labor Code and going after these penalties, it is a PAGA lawsuit. Whoops. There we go. So why are PAGA lawsuits uniquely threatening? And you're going to see some elephants throughout this presentation. Just a quick aside here. Nothing political was meant by elephants in any way, shape, or form. The elephant is intended to represent a business. I was trying to think of something that represents a business. And so an elephant it's strong, it's stable, it's moving along at its own speed. And the PAGA lawsuits are the way that business gets attacked. So the number one reason why PAGA lawsuits are threatening is the violations will multiply exponentially if there are actual violations of the Labor Code. So going back to the previous point about some Labor Code violations will have their own penalty. If they don't have their own penalty, which is the case for many Labor Code violations, under PAGA, the penalties are $100 per employee per pay period for an initial violation, $200 per employee per pay period for each subsequent violation. The authority is Labor Code 2699 F2, again, unless that violation has its own penalty stated, right? It's not a huge penalty, but the idea with a PAGA action is they are filed because the plaintiff's attorneys believe that there are enough employees or enough consistent ongoing violations. You know, if you're talking about a business that has, let's say, 20 employees or 25 employees, and you look in the last year and you've got 5 missed meal periods and maybe 3 missed rest breaks. Hopefully you don't have that, right? And we'll get to talking about looking at time records, pay records, auditing them, making sure that those violations aren't there. But again, if you've got a limited number of, let's say, break violations, that's not going to add up to that much. What these suits, what the attorneys on the other side are generally really seeking is companies that have ongoing consistent violations, ones where they believe that those violations happened every pay period and potentially for every employee, right? That's where the math starts to become concerning. So here's an example of a calculation, a relatively simple calculation. If a business had non-compliant wage statements, that is a Labor Code violation. If that business has 100 employees, if they're paid every week, 52 pay periods, that's $100 times 50. Well, that's 100 employees times 52 times $100. That's potential $520,000 penalty. Now, again, that would be something where In order to recover that at trial, the fact finder would have to conclude that those violations existed for all those employees every pay period throughout that entire year, right? That's not necessarily a guarantee, but I'm presenting this to show how quickly the math can add up in some cases, especially again if you've got consistent violations for every employee. PAGA plaintiffs can also potentially stack penalties. The word stack, the phrase stacking penalties, has got primarily two meanings to it. One of them is whether or not a PAGA plaintiff can stack penalties in the same pay period. So let's say you've got a 2-week period of time and there are rest break violations throughout them, or at least the plaintiff believes there's rest break violations. Can they also recover an additional penalty if there are, let's say, failure to reimburse expenses in that same pay period? That is an issue that in the case law, there's some authority on both sides right now. There's also a separate issue, however, though, which is the ability to stack the civil penalty that they can go after under PAGA with a statutory penalty. So certain labor code violations will also have an additional statutory penalty. There's a difference between civil and statutory. The cases have determined that, at least. There is authority for the idea that a PAGA plaintiff can stack a civil and statutory penalty in the same pay period. This is an issue that we talked about a little bit. This is one of the things that can drive a lawsuit or these types of lawsuits. Under the PAGA statutes, a prevailing PAGA plaintiff can also recover reasonable attorney's fees and costs. The danger with that is that if there are valid violations and the matter proceeds to a trial, and there's a finding for the employee, there could be a substantial attorney's fees award added on at the end. Now, I will say there are ways to address attorney's fees. There are ways to address costs separately. These cases often involve expert witnesses. Certainly if they're going to trial, they're going to involve expert witnesses, very likely on both sides, to talk about what the records show, because we may be talking about a lot of records at issue. There are ways to deal with potentially defending against a cost recovery, defending against an attorney's fees recovery. It'd be too much detail to go into all that stuff right now, but the issue of attorney's fees and costs does drive these lawsuits, because at some point, if the case proceeds and it's fought and there's discovery and depositions and things like that, the fees and costs will add up. Another reason that these types of suits are, I would say, uniquely threatening is there's no requirement that the employee be harmed by the labor code. My apology. Sorry about that. There's no requirement that the employee be harmed by the labor code violation. And in fact, there are certain labor codes where there needs to be some kind of an intent on the part of the employer. Courts have held for those specific labor code violations that because they're under PAGA and because of the language of PAGA, that intent doesn't apply. So there's even potentially greater liability for certain things than there would be if those claims were brought as a simple wage and hour action, let's say with the labor commissioner or just an individual plaintiff. There's also no requirement that the employer intended to violate the law. I will say that the issue of the harm and the intent of the employer, however, is very important, and we'll get to that a little bit later. So the big difference in terms of defenses between a PAGA action and a class action lawsuit is that class action lawsuits can be arbitrated. They can be individually arbitrated, meaning if a class action is filed and the business has a valid, enforceable arbitration agreement, and those can get a little tricky because the law has been changing a lot lately. We'll get to this later too, but I would say if you have arbitration agreements, get them looked at, get them updated if necessary. While we're on this, I wanted to say that because the law in California on arbitration agreements, and certainly in relation to these types of actions, has been changing. So a class action lawsuit can be individually arbitrated, meaning Joe Smith files as a plaintiff for a class action. If Joe Smith, the former employee, has an arbitration agreement that's valid with the business can say, we want to go to individual arbitration with you, meaning we want to go to a private arbitration, and at that point, it'll just be your claims at issue. Again, assuming you've got a detailed, well-prepared arbitration agreement. That is a significant defense, because what it does is it enables the business, the employer, to break up class action lawsuits, to take away a huge amount of the threat of them. The right to compel arbitration right now is up in the air for PAGA. Another slide on that one, I'll get to it in a bit. But while we're on the issue of the differences between class actions and PAGAs, class actions, again, have gone through a lot of litigation, a lot of appellate and Supreme Court decisions. And so the class in a class action has to be certified. They also have to present common issues. What it means is the courts recognize that we're looking at a lot of people potentially going to trial. Let's say it's a business with 500 employees, right? There's an issue of how do you try that case at trial, right? You can't have 500 people stand up and testify. And so class action lawsuits have ways to provide that manageability and say, well, we think that, this group of 100 people is significantly different than this other group of 200 people. It doesn't make sense to have them in the same action. With class actions, you can make those arguments, you can look at those things. There's more of a procedure with how they operate. PAGA, again, I think because of the scarcity of the labor code statutes that enacted it, you don't, at least right now, have that procedure.
Hey, Derek, we have a question that's just come in.
Yeah. Yep, please.
The question is, what if I already settled a legal claim with an employee that is now bringing a PAGA claim? What should I do?
So what I would say is, I think it's worth sitting down with an attorney first to look at the language of what the settlement agreement states. But there's appellate case law right now that unfortunately indicates that even if a PAGA plaintiff had, let's say, a previous, individual action with the business and the claims have been settled, that does not necessarily stop them from acting as a PAGA plaintiff. And the reason being, again, this goes back, the language of the case is not fresh in my mind, but it goes back again to the issue of this is an action being brought on behalf of the state. So a settlement with a former employee, even if it's for wage and hour violations, may not prevent a PAGA action from being brought. Now, if you've got a clear settlement agreement that says, all damages, there's other things associated with wage and hour actions. There's just basic damages like, hey, I haven't been paid all my wages. Those things can absolutely be settled. What I'm saying is that it may not prevent that person from being the face of a PAGA action, if that makes sense.
Yes, thank you so much. And that's all for now.
Thank you. So briefly on the issue of the arbitration, the status of the case law right now is there was a U.S. Supreme Court case, Viking River Cruises versus Moriana. The case was a little confusing to understand at points, but the basic idea that came from it and how most courts have, I don't want to say applied it, but have at least interpreted, is that PAGA actions can be arbitrated. In Viking River, because of the specific facts of that case, the U.S. Supreme Court said, there's an arbitration agreement here. Because of that, we think this individual person should go to individual arbitration, and the pool of other claims out there, the ones that are, being represented through the state, all the other employees' claims that are being brought into this, those should be dismissed. The California Supreme Court, in a case called Adolph versus Uber, is likely to address this issue. Without going into excruciating detail, one of the justices in Viking basically kind of held open the door for California, either the legislature or the California Supreme Court, to make a decision on standing. And so what Adolph is likely to decide, based on people that have looked at it, is the issue of standing, meaning even if there's an individual arbitration agreement, can a plaintiff still go forward with a PAGA action on behalf of the state on behalf of other employees' claims. That again is something that is going to be decided likely by the California Supreme Court. May 9th was the oral argument on that case, and the decision is expected within 90 days. So it's something that's going to be coming out likely soon. And we will get to in a little bit ways to, I would say, tighten things up for businesses that may need to do it. So what causes a PAGA lawsuit to be filed? Plainly, it is labor code violations. It is, and I'm not even going to pretend that this is the full list, because labor code has a lot of different things to it, and some of those violations have been interpreted by cases. So minimum wage, common violation, meal breaks, rest breaks, overtime, wage statements, misclassification or exempt. By that I mean, does the business potentially have somebody as an independent contractor when, excuse me, when really they're employee? Those are not good situations, because excuse me, if the person is in fact an employee and they're misclassified and that goes on for some period of time, there could be ongoing violations associated with it. The other I would say misclassification issue is whether or not somebody's exempt from overtime, whether or not they're properly under, an administrative exemption, executive exemption, or some other exemption that pulls them out of the requirement to pay overtime. Sometimes those decisions, or sometimes those positions, they may not actually be exempt in reality. And so that's another thing that you will see as a labor code violation. Waiting time penalties. We talked about the misclassification for independent contractors. Another one here is suitable seating law, which is something that a lot of employers have not heard about. I'm going to give an example here of a rest break violation, and this is intended to, the labor code and wage and hour laws in California, there's no other way to say it other than there's a lot of detail, there's a lot of requirements, they can be complicated, and violations can start to occur unless you're really on top of them. Example here with the rest breaks. So a rest break, this is pursuant to labor code, must be taken in the middle of a 4-hour period insofar as practicable. So if employees are taking rest breaks, it should be roughly in the middle of that 4-hour period. I've seen cases where rest breaks, for whatever reason, because of the flow of business, because of the change of shifts, sometimes rest breaks wind up not being given until right before a new shift comes on. So essentially at the end of a 4-hour period. Now, the employees involved may be fine with that. They may have requested that, right? But if that happens, it happens routinely, and it's not in the middle of the shift, it creates what I would say at least is a gray area, right? I don't want to say this is an absolute out and out violation, especially if you had a situation where you have a group of employees who are requesting to do that, right? And because of the function and the operation of the business, that's really when it absolutely works best. But what I would say is it's probably in most cases not a good idea, or it's something that requires more analysis, more looking at it before a policy or an informal policy like that is something that you allow to continue. And the reason being is, again, everybody might be fine with it, but all it takes for a PAGA action is one employee, current or former, to say, I think there was an issue here, I didn't like it, and I want the entire policy of the business to be looked at. Here's another issue of rest breaks. So rest breaks must allow an employee to be completely free from control. Employees on graveyard shifts that can't leave stores may be a violation depending on the limitations on what they can do. The idea with a meal break or a rest break is that that person is free from the control of the employer, right? Now, it doesn't mean that they have to be forced to be free from the control of the employer. They can generally do what they want to do on a break. But that concept of they need to be free on the breaks. So for meal and rest breaks, this is a common thing. Some of you may have encountered this. You may have encountered it, in the context of possibly a lawsuit, possibly a labor commissioner action. If meal and rest breaks, certainly for meal breaks, if meal breaks aren't recorded in some way, it's leaving open a claim that they weren't taken. It's just, if that's an issue in records, that's a big no-no. You got to make sure that meal breaks are recorded. For rest breaks, we have a lot of clients that in some way will verify that employees are also taking rest breaks, whether that's, physical time cards that they check something stating that they have taken all their rest breaks, whether it's something that they have to check on perhaps, a software program that does payroll and time, some way, or some kind of a separate written document. But you need some way to be able to say, hey, this employee is verifying to us that they took their rest breaks. And part of that too also is really encouraging people to take breaks. We'll go into some of that a little bit later. But a common thing you'll see with wage and hour cases is that if you don't have this proof in the documents, it opens it up for an employee to come along later and say, well, actually, I didn't take my rest breaks, And the question is usually, well, why didn't you say something about it? Why didn't you bring it up with us, right? There's a lot of lawsuits that are filed, and the employees might have never ever brought up any issues with breaks. But I would say the employer is held to a higher standard. You want to have records that you can say we've got conclusive proof that these things happened. Not that the more you get into needing to introduce testimony about what really happened 6 months back in time or a year back in time, the more it just leaves things open. Failure to reimburse work expenses can be an issue. Employees need to be reimbursed for all expenses associated with their job. This is an issue with remote employees to some degree now. If you have remote employees that are working from home and they're using their cell phone all the time, they're using their internet, those things need to be reimbursed. It does not mean that they need to be reimbursed for the entire amount of it. It is a reasonable proportion is what the cases indicate. But that is something to look at because obviously businesses have had to change in how they do things recently, and a lot of people are winding up using their own devices. There's even been lawsuits filed seeking reimbursement for physical office space and furniture used by employees. I personally think this is likely to go nowhere. I don't think that's something a court is likely to uphold. I think it's an aggressive tactic likely by a plaintiff's counsel, but just to give you a sense of what sometimes is claimed. If you have on-duty meal periods, they're only lawful if the nature of the position requires it, and you got to have a proper written agreement in place with the employee. Same thing with a meal period waiver. If they're only working 6 hours and they just work straight through, don't take a lunch, that has to be in a proper agreement. Those agreements can be rescinded later. Suitable seating violations. This is something that a lot of the big box retailers, Home Depot, I know, Costco, I think, has had lawsuits on this. The issue generally is, can an employee do their job seated without a negative impact, right? And take a cashier at Home Depot, for example, right? Most of the time, there's a pretty strong argument that they can't do their job seated because part of it's simply the perception of customers coming in, and it's not something that businesses do. But there's also an issue of, should the employee be provided seating when they're not doing anything, right? So cashiers may need to go throughout the store and do different other things. They may have other duties, right? This set of laws doesn't mean that employees should just have places to sit all the time and not do anything. That's not what it means. But it means if there is a cashier, for example, at a retailer, and they spend a good deal of their day just standing there, waiting for customers to come in and deal with them. If that is the role, the business may need to provide a seat for them while they're not doing anything. There was a AutoZone case where it was allowed to proceed to trial on the issue because the workers, in order to get a seat that was sufficiently high for the counter at AutoZone, had to go down to the manager's office each time and take the seat back to the counter. And in that case, the court said, well, it's an issue that we're going to let it go to trial on that issue. Again, we talked about violations can stack. Failure to pay meal period premiums can mean also a wage violation. I'm going to go through some of this a little bit quickly because I know we're probably running out a little bit of time. How to avoid defeat PAGA lawsuits. So PAGA lawsuits are always best avoided. Again, we talked about them not being a regular lawsuit. They are avoided by having excellent employment policies, enforcing them, excellent record keeping, detail, and also supervision by payroll people, HR, managers. Think of those people as the first line of defense. Again, if you got a situation where it's a clear violation, it's largely a math issue at that point. So what I would say is, for all businesses, do an audit of the time and pay keeping processes, policies, and practices. Look at the records, look at the handbooks, give some thought to how these things are actually applied, what the potential issues are. It can be worth it to take it to an attorney because they can stress test it. They can look it up on the other side and go, well, if I was going to file a lawsuit, I would look at these. This could be an issue. Can you guys prove this? And don't look at it as, are there potential issues with policies? Look at it as, can we conclusively prove there's no issue later, right? If you've got amazing records, if you have employees signing off on the correct things, it goes a long way towards making sure that these lawsuits either aren't filed in the first place, or if they are filed, a lot of times you can have that discussion back and forth with opposing counsel. At some point, they're going to want the records. And if those records look perfect, it's going to diminish what they think of the case. Again, detailed compliant policy is one of the best ways to avoid and defeat them. We talked about some of the common issues. I won't go into those right now because I know we're probably getting short on time. Employee handbook, I would say, is it compliant? Is it up to date? Does it incorrectly state the law in any way? Sometimes you'll see a handbook that doesn't have, it's just the way that breaks are addressed is not quite in compliance with the law. Those things will be used against an employer, right? The other side will say, this is the official policy of the employer, right? For example, overtime isn't paid without authorization. Got to pay overtime no matter what. I also say, go above and beyond in terms of encouraging things like meal breaks, rest breaks. The reason being is you've got to let people know, you've got to let employees know that they have the right to take these, but encourage them to do it. Because again, one of the common issues is you see is the employee will come back later and go, well, my manager made it hard for me to take a break, right? And then again, you're getting into what one person says versus what another person says, but you want something in writing, making it very clear.
Hey, Derek.
Yeah.
Question for you. How often, this is from one of our attendees, how often should I do an audit of our business/HR practices?
So business HR practices, I would say, it can depend on the type of business. It can depend on the number of employees at the business. It's not a bad idea to do it on a yearly basis. And I say that simply because California comes out with new employment laws all the time. We do reviews of handbooks for clients all the time. And a lot of times it's, well, we don't need to add much of anything, but great, we looked at it, sometimes it might be specific to that industry. So I think it's worth doing on a yearly basis. Yeah.
Thank you.
So in addition to the policies, the actual practices have to support them and enforce them, and make sure that it's being carried out. Managers, payroll, HR has to be properly trained to enforce and supervise these policies. Again, make it easy to notify the company of any changes or any issues that an employee may have with pay, with time, that they can raise these things easily. I would say some people on the presentation may not want to hear this, but it really helps if managers at least have an understanding of the legalities of how rest breaks work, overtime work, basic things like that. Because sometimes that manager on the ground is the one kind of making the decisions relating to this stuff. And so unless those decisions are all going through HR or someone else, it's a good idea to make sure managers know that. Managers should be raising repeat issues with owners higher up, regional managers, district managers. You know, if people are saying, hey, we're short-staffed, can't take a break, things like that, if that's happening on more than one occasion, that should be something that somebody higher up also is likely aware of, so that it can be addressed, because those things can be, well, I'll say it, those things can be exaggerated, you know, later. Payroll HR, good idea. Also understand the basics of wage and hour laws. I would say document everything. I'm a huge believer in documents. You know, email sometimes works great for that. Even if there's conversations regarding pay and time, be able to recreate what happened down the road. So this is a form that we've used for some of our clients. This is a request to correct employee time, their breaks, things like that. Our firm uses something like this internally as well too, although we do it electronically. But the idea is, you know, if you've got a lot of employees, you may need to make changes to things, or people may come to you with that concern, which is, hey, I didn't get a rest break the last 3 days, it was really busy, right? So you want to record that somehow. You want to be able to show that this employee said, hey, there was an issue. We had them fill this out. We made these forms readily available, easily available. They knew that they should use them. We take them in, and then the company knows, you know, hey, there's an issue here. You can look into it. And if there was, in fact, an issue, the penalty can be paid then, you know. If for some reason somebody didn't get breaks, because let's say it simply was too busy. And so that issue can be taken care of. And then if for some reason there's a PAGA lawsuit, you can say, look, they raised it with us. Here's the form. Here's what they did. Here's what we did. You know, again, it's paperwork, but it's really important to be able to prove things later. This is another policy. This is a short policy. Again, breaks should be able to be something that's verified, and a lot of this language here is something you probably see in an employee handbook. But I like this as a separate, sometimes standalone document, simply because if these cases are tried, if they're litigated, in some ways they're much like a simple labor commissioner action. You know, you sit the person down, the former employee down, and you say, you didn't take breaks on these days, right? Well, why, right? And then if you have something like this that you're able to show them that says, look, we're encouraging you to take them, we're telling you to take them. If you're not able to take them, you should let us know. There's a section in the third paragraph where you can, you know, contact the manager or human resources. You can put an HR email in if that's something, you know, that you give the employee multiple ways to say there's an issue, or my time wasn't correct, or whatever it might be, so that one, you avoid something which tends to be a common thing, which is I couldn't talk to my manager. You'll hear that sometimes. If you got the email here as well, they can send an email and say, look, you know, my time, you know, wasn't correct on my time cards. I'm just asking that it be corrected.
Hey, Derek.
Yep.
We have an attendee wondering if you're able to share these forms after the session.
Yeah. I mean, I can. I think they might need to be tailored, I would say, to the specific business. A little, only because people do things different. They'll certainly be part of the presentation, and I can certainly also provide them separately as like a PDF as well too. Yeah, I would just say every business can be a little different. You know, each business can have its own areas. You know, construction is going to be different than a retail store. It just is. And so before you use the forms, it's probably worth it also to talk to an attorney. So sorry, to answer the question, you absolutely provide the forms. Going back to the point about you know, managers and HR and payroll having a basic understanding. This is a great book. You can get it at store.calchamber.com, California Chamber of Commerce. Really good book. Really good resource for understanding most employment issues. It's well written. It's pretty clear. It's a great resource to get. So we talked about this a little bit before. I'll just go a bit through the litigation process here if these cases are actually filed. Again, you're going to have that pre-litigation LWDA letter that says to the state, there's the issues here. There's a limited right for the employer to cure certain violations. So certain issues dealing with the pay stubs, those can be cured. Those can be fixed once the letter is served within 33 days. So importantly, if those are something that is an issue for the business, if you get one of these letters, reach out to counsel right away. Absolutely right away. And part of the reason being, again, is PAGAs have a 1-year back. So if there happens to be violations, fix them going forward, you know. And again, there might be a cure right that the business has to fix some of those things that needs to be jumped on. So for litigation, again, have up-to-date compliant arbitration agreements so that if there is some kind of a class action alleged as well, that can be separated out and dismissed. I'd say each case needs its own assessment. It's hard to give blanket advice on any kind of a lawsuit, you know. I would say this though, and this is a personal practice, I would say, is if the case revolves heavily on testimony, right? Sometimes what happens with these cases is, in some cases, you get a disgruntled former employee. You may have an employee who happens to have labor code violations, but no one else does. And so that plaintiff's firm may only be hearing, possibly, what that person is saying. And so in a lot of cases, it makes sense to take the deposition of that plaintiff, right? That way you get to find out what they're going to say. That way you get to really get to the heart of it. You get information quickly. You also can show to the other side the weaknesses in their case. In most cases as well, gather witness testimony, gather declarations. Again, work through counsel to get these things. You want people built up to support the company. Again, if it is a situation where you have a disgruntled employee, it will happen. But you have a business where you have 40 other employees that love working there, and some of them may have had issues with that plaintiff. You want people to be able to say, hey, I saw Joe Smith take meal breaks. He would do this. He would go outside to smoke, right? You need the story, and you need to start locking it down fairly early. Engaging an expert in certain cases may be advisable. They can do calculations if there are violations, potential exposure scenarios. I would say also there might be a manageability defense. This goes back to the issue of, you know, how do you try a case with 500 people in it if you have a large company? There's a case, Wesson, in which the court actually struck the PAGA case because it was involving 346 general managers, and the facts were basically each one of those managers had a different situation. They didn't have the same overtime exemptions. They didn't have the same type of job. They were at different locations. And so you're looking at a case where you've got testimony of potentially hundreds of people, and it's just not manageable. There is a contrary case called Estrada that goes the other way with this in California. It is something that can be raised if you're talking about, again, a situation where things are not the same amongst all the people there, all of the employees or former employees. I'd also say act in good faith and correct issues. This is important. Courts have the authority to reduce a PAGA penalty if it's unjust, arbitrary, and oppressive, or confiscatory. Example, the Fleming case, there were penalties that were reduced from 2.8 million to 500,000. It was a very large company, but in that case, there was no damage to the employees. They didn't lose wages because of it. The employer wasn't aware that these violations were going on. When they found out about it, they took steps to promptly correct it. So courts will, in the right situations, significantly reduce these things. This is still a large amount. It was a big company. I forget how many. It was hundreds of people. But that is something to look at as well. If there really are violations, fix them. There's a potential exemption. I know a lot of people here are in the construction industry. If you don't know, Labor Code 2699.6 says that PAGA can basically be waived by the correct kind of collective bargaining agreement. May not be a situation in which your business has a collective bargaining agreement with unions, but if you do, I would say certainly make sure that it waives PAGA correctly, because the requirements aren't that onerous. So as long as the collective bargaining agreement provides for wages, hours, and conditions, which they often do, and the pay rate's not less than 30% more than minimum wage, and you get proper pay for overtime, and it expressly and clearly waives PAGA, you can waive PAGA. So if there is a union associated with the business, look at getting that in place. One last thing, ballot initiative. So these lawsuits are a scourge, I would say, to many businesses. And I say that again, primarily because in a lot of cases I've seen, the business didn't intend to do anything wrong. So there's the California Fair Pay and Employer Accountability Act. It's going to be on the November 2024 ballot. It's a ballot initiative. The idea is it would repeal PAGA. It would take it away from being something that private attorneys can file, and it would increase funding for the state agencies, so the state would go after it. 100% of the recovery would go to employees. This doesn't mean that PAGAs would go away, but it takes out that attorney's fees issue. It takes out a profit incentive. I also think it's better because the money's all going to the employees. So that is something that got enough votes. It will be up in November 2024. And I know we sped through it, but you all made it to the end. And if anybody else has questions, please let me know.
Thank you so much, Derek. We have one comment that came in saying that they were requesting that we share with the other attendees the efforts being made by the Chamber and many other business groups to obtain PAGA reform via initiative next year. And they shared it's cafairpay.com. So I'm not sure if you're familiar with that, Derek, but.
Yep, thank you. No, yeah, there's a lot of good groups out there and organizations that are trying to do something about this.
Perfect. And then we do have a couple other questions. Again, if you do have questions, feel free to use the Q&A section to send those in. This one says, it says, this PAGA lawsuit or law is very frustrating. Can I sue the employee bringing the PAGA action if they were a terrible employee or caused damage to my business?
Yep, we get that question a lot, potentially. So it can be a complicated question. Terrible employee is usually not something that's recoverable, even if somebody's been pretty negligent. If you're talking about something where it's bad job performance, negligence, things like that, generally, and this applies to pretty much all employment lawsuits, the employer is probably not going to be able to sue. If an employee went out and stole things, if they intentionally damaged things, if they completely defamed the employer and the owners online or something like that, there may be claims associated with that. That is a complicated issue, though, that you'd have to talk to counsel about. And part of the reason being is you want to make sure you've got something solid. I'll put it that way. You don't want it to look like the lawsuit that's going back against the employee is just a way to kind of retaliate against them. But if there are valid grounds, valid claims, valid damages, it's absolutely something to talk with counsel about. Yeah. And I agree, they're a frustrating lawsuit.
Thank you, Derek. A question we have is, will insurance cover a PAGA action?
So I will defer to Roland on this, and I'll also ultimately defer to the insurance policy itself. The insurance policies are very heavily governed by what their terms are. I'll actually, Roland, if you wanted to address that one,
There I am. Okay, little delay. Yeah, it's always a good question, and I'll say it this way: not all insurance policies are the same. What we have experienced, and I say we, Bender Insurance Solutions, for our customers is coverage sometimes can be triggered under the wage and hours sublimit. But, and this is just kind of an open statement. When you are faced with a PAGA lawsuit or any lawsuit, it's always a best practice to share that lawsuit immediately with your insurance broker to find out if there's coverage. But normally, we've seen it covered under the wage and hour sublimit. Thanks, Derek. Hope that helps.
absolutely. Thank you, Roland.
Thanks, team. So that seems to be all of our questions that we've received today. I wanted to give a little plug for our June Bender U that we're going to be having. If you wouldn't mind clicking over to that next slide for me, Derek, that would be wonderful. It's going to be on Thursday, June 22nd. It's about IIPP, which I know is applicable to many of our attendees here, especially our construction companies that are in attendance. You can go ahead and scan this QR code with your phone. It'll take you directly to our registration page. Again, I just want to thank Derek for sharing with us today. We appreciate you all for taking time out of your busy schedules to join us for today's Bender U. And as a reminder, this session has been recorded, and both the recording link and a copy of today's slide deck will be emailed to you following the webinar. But should you have any additional questions that arise, we know that tends to happen once you start thinking on the topic a little bit. Please feel free to reach out to us, and we will be happy to help you. Thank you again, and we hope you all have a wonderful day. And thanks again, Derek.
Thank you. Thank you all. Thank you.